Hey everyone, Noah here. This is not a hypothetical. This is a legal detonation happening in real time, and its shockwaves will redefine what accountability looks like for the most powerful people on Earth. A former First Lady of the United States is now on a collision course with a sworn deposition, compelled by the federal judiciary to answer invasive, foundational questions about the nature of her marriage, the truth of her residency, and the intricacies of her financial life. The mechanism forcing this unprecedented exposure? A catastrophic miscalculation by her own legal team. We are witnessing a rare, self-inflicted legal catastrophe. This isn't speculation based on leaks. It is the direct consequence of court filings, procedural rules, and a judicial order that has sent Donald Trump's attorneys into full-scale crisis management. The trap has been sprung, and there is no elegant exit. To understand the magnitude of this moment, you must first rewind the tape. Last fall, veteran investigative journalist Michael Wolff, author of several searing bestsellers on the Trump White House, opened his mail to find a classic instrument of Trump world intimidation: a billion-dollar defamation threat. The letter from Trump-aligned attorney Alejandro Breto demanded a full retraction and apology for Wolff's reporting on Melania Trump's social connections to the late Jeffrey Epstein. The implied threat was existential: recant or be financially obliterated by endless litigation. The standard playbook for recipients of such letters is well documented: immediate, abject capitulation, or a retreat into terrified silence. Michael Wolff chose option C, a move so audacious it reset the entire board. He did not wait to be sued. He sued first. In a preemptive strike filed in New York State Supreme Court, Wolff didn't just defend his reporting, he went on the offensive. His lawsuit meticulously detailed each statement the Trump team alleged was defamatory and systematically dismantled the claim, arguing they were either substantively true, constituted protected opinion, or were grossly misrepresented out of context. More crucially, he framed the billion-dollar threat for what it was: a strategic lawsuit against public participation, a slap suit, a weapon not designed to win in court, but to bankrupt and silence critics through the sheer grinding cost of legal defense. This is where Melania Trump's lawyers made the fatal error. Facing Wolff's aggressive countersuit in state court, they attempted a tactical retreat. They filed a notice of removal, seeking to yank the entire case out of the New York state system and into what they presumed would be the more favorable arena of federal court. By a twist of fate, the case landed on the docket of Judge Mary Kay Weiskachel, a federal judge appointed by Donald Trump. On paper, it looked like a masterstroke: escape the unpredictability of a New York jury and secure a supposedly sympathetic judicial referee. But this maneuver contained a hidden self-destruct mechanism. Federal jurisdiction is not a free-for-all. It requires a specific legal foundation. The most common pillar is diversity jurisdiction, which demands that the plaintiff and defendant be citizens of different states. Michael Wolff is a New York resident. For the case to properly belong in federal court, Melania Trump must prove she is not a New Yorker. She must establish, legally and factually, that her true domicile is elsewhere, presumably Florida, the state of the Mar-a-Lago Club and the Trump family's claimed official residence. And here is the pivot point that changed everything. By invoking federal diversity jurisdiction, Melania Trump's team triggered a procedural right for Wolff's attorneys: the power of limited jurisdictional discovery. Let that term sink in. Her own legal strategy has now handed her opponent the key to unlock a deposition. It has authorized them to issue subpoenas, demand documents, and pose written questions, all laser-focused on a single, explosively personal issue. Where does Melania Trump actually live? Think of the questions that are now not just permissible, but inevitable under oath. On how many nights in the past calendar year did you sleep at Mar-a-Lago versus Trump Tower in Manhattan? Where is the primary residence listed on your most recent federal and state tax returns? Do you claim Florida's lucrative homestead tax exemption? If so, what evidence do you have of physically residing there to qualify? What address is listed on your driver's license, voter registration, and car registration? Where does your minor son, Barron Trump, primarily reside during his studies at New York University? What residency status was claimed on his tuition forms? This last point is a tripwire. NYU tuition rates differ drastically for in-state versus out-of-state students. Any claim of New York residency for tuition benefit would atomize her claim of Florida domicile for this lawsuit. Now, some might assume Judge Weiskakil, given her background, would simply shut this down to protect the former First Lady. But that misunderstands the nature of judicial authority here. Jurisdictional questions are foundational. The rules of federal procedure are unambiguous. When a party's right to be in federal court is legitimately challenged, the party seeking that forum must prove its case. The challenger is entitled to test that proof through discovery. Even the most favorable judge cannot simply ignore black-letter law. Given the ample public reporting on Melania Trump's pronounced preference for New York over Washington or Palm Beach, Wolf's team has more than enough good faith basis to demand this inquiry proceed. Let's be clear about what Wolf actually reported, the statements that sparked this blaze. His defense reveals how perilously weak the original defamation claim likely is. Statement: that Melania was very involved in the Epstein situation. Wolf's defense: this was ripped from context. His full reporting stated she avoided the topic publicly but was active behind the scenes, a standard journalistic observation, not defamation. Statement: that she could be the missing link between Trump and Epstein. Defense: a protected opinion based on documented facts and relationships. Statement: that she was in Epstein's social circle and that's how she met Trump. Defense: a verifiable fact supported by modeling agency records and social histories from the time. Statement: that she was introduced to Trump by a model agent connected to both men. Defense: demonstrably true. Statement: regarding Epstein's own allegations about the Trump marriage. Defense: truthful reporting of what Epstein said. In essence, Melania Trump is now facing the glare of a jurisdictional inquisition into her private life, all to pursue a defamation case she has a slim chance of winning on the merits. This isn't just a bad strategy, it borders on legal malpractice. The implications cascade far beyond a single lawsuit. A deposition under oath is a minefield. Questions about residency inevitably bleed into questions about the marital relationship itself. How often does she see her husband? What are their living arrangements when together? Any inconsistency between her testimony, her financial filings, or her son's educational paperwork could open new fronts of legal jeopardy, from perjury to tax fraud investigations. For Donald Trump, this is the ultimate nightmare scenario. A legal process he cannot bully, delay, or derail with a tweet, threatening to force into the open the very details of his personal life he has spent a lifetime obscuring. The billionaire playbook of threatening lawsuits to induce silence has met its match in a journalist who called the bluff and turned the legal system against them. So, what escape routes remain for Team Trump? They are vanishingly narrow. Voluntary dismissal and retreat. They could try to dismiss the removal and slink back to state court. This would be a humiliating admission of catastrophic error, likely with prejudice to their position. Settle immediately. They could seek a quiet settlement with Wolf. But Wolf, smelling blood in the water and standing on principle, has shown zero interest. He wants the discovery. He wants the testimony on the record. Fight a losing battle. They can attempt to narrowly constrain the discovery, but the procedural rules are firmly against them. The judge's discretion is limited on this foundational issue. The most probable path forward is also the most damaging. The deposition will happen. Melania Trump will sit in a room with a court reporter and opposing counsel, and she will be required to answer. Every response will become part of the permanent legal record, a new layer of documented truth available to future investigators, journalists, and historians. This moment transcends one family's legal woes. It represents a critical test of whether America's legal architecture can withstand the weight of wealth and power designed to bend it. Michael Wolff's refusal to be intimidated, his decision to sue first, has flipped the script. It has exposed a profound truth. The legal intimidation playbook only works in the shadows of threatened litigation. The moment you are forced into the light of actual judicial procedure, you must play by its rules. You must produce evidence. You must answer questions. You must tell the truth. The crisis mode now engulfing Trump's lawyers is a direct symptom of this new reality. They are no longer the aggressors sending threatening letters. They are defendants in a procedural trap of their own making, scrambling to protect their client from the consequences of their own strategy. The judge's order is not a suggestion, it is a command. Testimony will be forced, the questions will be asked. And for the first time, on matters she has fiercely kept private, Melania Trump will have to provide answers under penalty of perjury. This is the sound of accountability arriving. It is not loud or dramatic. It is the quiet, methodical click of a procedural rule being invoked, a deposition notice being served, and a legal shield being transformed by sheer miscalculation into a glass house.